All right, hello everyone. Thanks for coming. Welcome to the Harvard Law Forum. Before we start, I just wanted to get sort of a head count. Could you raise your hand if you're a 1L here? All right, thank you for coming, baby 1Ls. If you're a 2L, please raise your hand. Oh, nice. And the wise old 3Ls, please raise your hands. All right, thanks everyone for coming. Again, I'm Martin Drake. I'm president of the Harvard Law Forum this year. The Forum is the longest running American law school speaker series. Over the years, we've had people like Cesar Chavez, Thurgood Marshall, JFK, Jimmy Carter, Malcolm X, Eleanor Roosevelt, and many, many more. Before we start up, I just want to let everyone know that there'll be a sign-up sheet going around for the Forum and the Record, which are two of the great civic institutions at Harvard Law School that promote civic discourse and promote a civic spirit here at the school. One of the great things we did this year was put out a packet of Mr. Nader's writing that we gave to every 1L at the beginning of the year. Those packets are available on the table over there at the end. So please sign up on the sign-up sheet, write your name down if you want info on the Forum, write your name down if you want info on the Record, and please circle your name if you want to get involved and contribute to this civic spirit at the law school. Also on that theme, we'll be having a little chat afterwards for people who are really serious about contributing to civic spirit here at the law school by means of the Forum and the Record. So stick around for that. But for my part, as head of the Forum this year, I couldn't be more excited to introduce the two speakers for today's event, entitled Harvard Law School, Corporate Power, Corporate Law Firms, and Your Future. As students here at HLS are told over and over again, we are the best and the brightest. We are here to hone our arguments, to hone our intellect, and our expertise. We solve the most complex puzzles with elegant solutions. If you had any doubt about that, you can just look at our scores on the LSAT's logic game section, where we solve such crucial legal questions as determining the correct order of the inspection of factories A through F, based on some strange constraints of the factory inspectors. But something that we're not often told here at Harvard Law School is which problems we ought to be solving. Does it matter how we use these incredible analytic skills? Is there any obligation on members of the legal profession to use our skills to contribute to the public good? And do law schools like Harvard, which train the leaders of the future, as Harvard would be the first to tell you, hold any responsibility for the direction of the legal profession? Our two speakers today answer all of those questions with an unqualified yes. It seems maybe a little redundant to go through the work of our second speaker, Ralph Nader, because everyone here encounters his accomplishments nearly every time they step outside their doors. You might have run into his name after wondering, who was it that was responsible for the Clean Air Act, or the Clean Water Act, or the popular use of the word whistleblower? Without this Harvard Law alum's efforts, we wouldn't have the Freedom of Information Act, the Occupational Health and Safety Administration, or the seatbelts and airbags in cars that save millions of American lives. He's proof of what can be done with a Harvard Law degree when it's wielded in service of the public. Or, as former Speaker of the House John McCormick said of one of Nader's many accomplishments, his work is proof of the power of, quote, the crusading spirit of one individual who believed he could do something. But first, we'll hear from a more recent Harvard Law graduate who embodies that same crusading spirit, and he brought it with him to effect change here at the Harvard Law community, Pete Davis. During his time at HLS, he opened our eyes to the crisis in the legal profession with his groundbreaking report, aptly named Our Bicentennial Crisis, a call to action for Harvard Law's public interest mission. There's copies of the report at the front, which if you're particularly interested, then you can get a copy. In his report, he detailed the multitude of ways that students are funneled into a legal practice that serves the wealthy and powerful, what he dubbed corporate interest law, at the expense of the public good. But he didn't just stop with criticism, as is pretty easy to do for a lot of us lawyers. Pete had a multitude of proposals for Harvard Law to remedy this corporate interest practice and to further its mission statement, which is to educate leaders who contribute to the advancement of justice and well-being of society. You can see a bunch of his proposals that are detailed in his recent piece in the Record, which I believe was published October 22nd. Regardless, here to tell us more about corporate power, corporate law firms, and your future, let's get it up for Pete Davis and Ralph Nader.
Thank you so much. Let's hear it for Martin Drake. Martin Drake is one of he's one of my inspirations. He's the real deal. He lives his values, and I think living our values is one of the most important things that we can do. I'm Pete Davis. I'm from the class of 2018. I just graduated last year, and in the spirit of Halloween, I am back to haunt as a ghost the campus. And I wrote this book, Our Bicentennial Crisis, as Martin Drake said, and I wrote the book because I love Harvard Law School, and I care about it as an institution. And I decided to not stand outside of the institution. I decided to say, I'm part of this institution, and I care about what it does in the world, how it is as a neighbor to other institutions in the world, and how it can change. Part of loving this institution of Harvard Law School is I love the history of Harvard Law School because it's full of exciting stories and inspirations for how that history can continue with us. So I'd like to begin with this history. For most of Harvard's 2 centuries, very few graduates went to go work in what we now consider the public interest. But there's always been fighters for more public interest work coming out of Harvard Law School. The first fighter was John Quincy Adams, 6th President of the United States, and the first famous legal graduate of Harvard University. He gave his graduation speech and titled it, "Upon the Importance of Necessity of Public Faith to the Well-Being of a Community," which was like revolutionary speak for our bicentennial crisis. Except it was probably like pre-centennial crisis because it was before Harvard Law was created. And he warned his fellow graduates about how, quote, "the contracted bosom, which was never expanded by the warm and generous feelings of benevolence and philanthropy, may slight all public engagements for the sake of a paltry profit." That's what John Quincy Adams said. He was worried the revolutionary spirit was gone a mere few generations after the revolution. When the Harvard Legal Aid Bureau was created at the turn of the century, there were people who were fighting for that, and there were people who were fighting against that. An alumni newsletter assured readers that students would, quote, "sacrifice comparatively little time for the effort of helping our impoverished neighbors," while at the same time, in that same newsletter where they're like, "don't worry, the Harvard Legal Aid Bureau won't do too much work," they took pride in the students who were members of the Massachusetts militia who were excused from exams to serve in the suppression of a textile workers' strike. So bragging about them, not bragging about the Harvard Legal Aid Bureau. During the civil rights movement, there were a few civic-minded students who dove headfirst into it. I did a deep dive of the civil rights movement at Harvard Law School. One student, very inspiring, Elizabeth Holtzman, would eventually become a congresswoman. She spearheaded the Civil Rights Research Council, served in Albany, Georgia during her summers for civil rights groups, spent her time at HLS getting the word out about what was happening in the South, and helped say we need to use some of Harvard Law's resources to help this cause. But here's the record excerpt from February 1964 on how most students related to the civil rights movement. So, student newspaper report during the civil rights movement, quote, "For the most part, the third-year students who have jobs in southern cities will be doing corporate tax and business work. Although a significant number expressed interest in criminal and civil rights cases, none said they would seek them. particularly in the first few years of practice, the feeling that effective work in the civil rights area can only be done by one who has first established a legal reputation in the community. One senior said, if there were any hope in doing any good, I would do it, but it doesn't look like it. It takes a lot of guts and idealism to go back and work without a chance of success. And so that was someone saying there's no hope in the civil rights movement in February 1964, the same year that they passed the Civil Rights Act that year, and the Voting Rights Act the next year, and housing civil rights 2 years later, and had a bunch of students going down and fighting for civil rights. Some Harvard Law students were saying, there's no hope, I'll wait until I'm a big professional corporate attorney and then I'll fight for civil rights. One more piece of history, the first recorded reference to public interest lawyering on Harvard's campus came in 1968 when the man sitting behind me called for more of it in a speech. He called on Harvard Law students to join him in helping build public interest law firms that would counterbalance the power brokers of the large firms. When all 500 law school graduates in the class of 1975 from Harvard go into these public interest law firms, finally we can say that we have arrived at a relatively sane deployment of legal manpower. I would have done an impression of you, Ralph, but I was going to spare you in the audience. And he hung up, raised the flag and said, come join me, and a bunch of Harvard law students signed up to join him and fight for this. But even by the class of 1975, in Ralph's own words, most lawyers coming out of Harvard labored for, quote, polluters, not anti-polluters, for sellers, not consumers, for corporations, not citizens, for leaders, not rank and file, for not against rate increases or weak standards before government agencies, for highway builders, not displaced residents, for preferential business access to government, and against equal citizen access to the same government. And then the dean started taking notice because there was a groundswell of people starting to talk about this. And Dean Erwin Griswold, on the 150th anniversary of Harvard Law School, reflected, for some years now, I have been concerned about the effect of our legal education on the idealism of our students. I have great faith in our students. They bring a lot to the school, a large measure of idealism. But do they leave with less? And if they do, is that something we can view with indifference? If they do, what is the cause? What do we do to them that makes them turn another way, the dean asked. By 1989, after all of this fighting, we got to 6% public interest participation out of Harvard Law School after a century of work. But then came along this new dean, Robert C. Clark, who 6 months into his tenure ended the public interest advising at the school, said it only served symbolic guilt alleviating purposes. But then something changed. It changed the only way that things tend to change. A group of people got together and decided to fight back. Students in the classes of 1990 and 1991 wrote letters, held rallies, held press conferences. They made t-shirts emblazoned with guilt alleviators on them. They called themselves the Emergency Coalition for Public Interest Placement, ECPIP. They made national news. They started a student-faculty committee, and the administration changed course. They reinstated the position. They turned that position into an office. They grew that office. When the new building came along, they gave them a literal bigger office. It's called OPIA today, Office of Public Interest Advising. OPIA was dedicated to persuading students to, quote, hold on to their values. Suddenly, there was a professor named Gary Bellow who started fighting for clinical programs. There was only one clinical program when Ralph Nader was here at the school in the 50s. Now there's dozens of clinical programs. Dean Griswold had once said he hoped the school won't go overboard on clinical legal education. They did not listen to him. There's now 18 in-house clinics at Harvard Law. They even established a public interest-friendly mission statement to educate leaders who contribute to the advancement of justice and the well-being of society. Everyone should have that memorized. To educate leaders who contribute to the advancement of justice and the well-being of society. And in that work between 1990 and today, we got from 6% public interest to 18% public interest, which is about where we're at today. For every one person that goes into public interest, 4 go into serving corporate interests. For every one person that serves the public at large, or the bottom 90% of the income bracket, 4 students come out of Harvard Law School and for the most of their careers serve the top 10% of the income bracket and the small group of the wealthy and powerful organizations. So that is the history that I started writing this book knowing about. And so we got from 0 to 6% to 18%, and I was looking around at our school, and I said, where do we want this line to go? So one possibility of where we want this to go is to go backwards and go back to 6%. One possibility that most of the administration and the people that fought against my efforts here want is, let's just stay steady at 18%. And then I started thinking, well, what if we had that line? Where should that line go? And I started thinking, well, what if Harvard Law graduates were equally balanced across the legal needs in America? So you take all the legal needs in America. Domestic violence victims needing restraining orders, veterans not getting their benefits, employees victimized by $20 billion in wage theft, prisoners in poor conditions, startups needing antitrust to break up entrenched monopolists, victims of preventable hospital infections, farmers being disempowered by manipulative contracts, migrants affected by climate change, and yes, corporate boards needing mergers, acquisitions, tax, and regulatory help. All the legal needs in America. And you said, I want to sprinkle Harvard Law graduates across those legal needs. That would set a goal of about 95% of Harvard Law graduates going into what we categorize as the public interest if we distribute it across legal needs in America. Some people call this radical, so I decided with our bicentennial crisis to propose a moderate middle, centrist moderate middle, which is setting a goal of 51%, a majority of Harvard Law graduates devoting a significant portion of their careers towards advancing the legal interest of the poor and the public at large. HLS has produced folks who have fought money bail, passed the Freedom of Information Act, inspired the founding of Yellowstone National Park, and stood alongside farm workers, asylum seekers, and mothers of prisoners. It's also produced folks who've helped defang antitrust, facilitate Wall Street recklessness, drown out the voice of normal people in the legislative process, and stood alongside polluters, plutocrats, and bullies. My proposal is that HLS produce more of the former and less of the latter, so that we are worthy of our heft. So, when I proposed this, we're getting to, now I propose that, I started getting these excuses. I got 10 excuses that were thrown at me, and I wrote the book, which I hope you can pick up or check out at hlsreport.org, to kind of look into each of these excuses. So first excuse, this isn't a crisis. Why call it a crisis? I looked into that. Looks like a crisis in our criminal justice system. Our prisons have ballooned 8-fold. Many people experience their criminal defense as meet 'em, greet 'em, and plead 'em. Public defenders are underfunded relative to police and prosecutors. Looks like a crisis in our civil justice system. 86% of civil legal needs go unmet. England has 13 times as much civil legal aid per capita as we do. The 100 most profitable firms make $28 billion in profits each year, and all civil legal aid for poor Americans is $1 to $2 billion. Seems like a crisis in our political system. The Olin Foundation donates $18 million to Harvard Law School to teach what they said they can't admit is, quote, conservative constitutional law. I found out about that in a book for conservative legal advocates talking about great strategies that have worked in the past that apparently they circulate among the plutocrats, which is, and it was like, oh, I got to tell you about this great strategy. We donated $18 million to Harvard Law School to get a bunch of right-wing professors there to dilute the critical legal studies movement. It was super effective. You should do it at other law schools. It says that in the book. So that's a crisis in our political system when 34, for every one public interest lobbyist, left and right, lobbying against gay marriage, lobbying against immigrants, counted as public interest in this count. For every one public interest lobbyist, there's 34 corporate interest lobbyists on Capitol Hill. That's a political crisis. Other people tell me Harvard Law's employment numbers don't matter. Why are you fighting here? Well, this is our institution. And if we have 180 more people coming out of each class, going into public interest, it'll change the culture of this institution. It is a keystone lever. Where we go in our career afterwards is what determines the culture of Harvard Law, which determines the culture of the legal academy, which helps change the law system as a whole. People told me pro bono blurred the divide, but then I looked into it. Half an hour a day, half an hour a week, $50 a day goes to from corporate interest firms to public interest causes. Only 36% of lawyers meet 50 hours a year of pro bono. Charitable giving, does it blur the divide? The most giving firm by far gives 0.02% of its revenues to public interest legal causes. Some people said everybody deserves a lawyer. Don't the corporations deserve a lawyer too? I said, finally, we're getting somewhere. Everybody deserves a lawyer. Let's talk about everybody deserves a lawyer. I'll give you that. But let's talk about the distribution of lawyers. The clients that are served by these corporate interest law firms are disproportionately white men. The stockholders, the corporate board members, the CEOs, disproportionately white men. The clients of public interest organizations are disproportionately women of color. So we're already talking about some people deserving lawyers more than others in the current setup of the system. Let's talk about geography. 70% of Harvard Law students go to just 4 states, New York, California, Massachusetts, and DC. New York has more lawyers coming out of Harvard Law School than the other 47 states combined. So you start painting this picture where you suck in a diverse group of people from all around the country and then send them to New York to work mostly for white men to help their corporations be more efficient and more profitable. Graduates take public interest jobs later. That was another excuse. Not true. 7.2%, according to our own study, who are working in corporate law right after school are working in public interest 10 years later. Most people just stick in corporate law after they go there. Students are free to choose. Well, I'd be fine with students are free to choose as an excuse if not for the fact that when polled at the beginning when people come into law school, 3/4 of students say they want to work in public interest, but only one-fifth end up doing so at the end. Something is changing you while you're here. Some say this involves factors beyond Harvard's control. CUNY has 70% of people go into public interest. Yale beats us, Georgetown beats us, Northeastern beats us. We are falling behind. We are not a top-tier school in terms of public interest commitment. Harvard Law is a path to the upper class. Why are you ending this dream organization that's taking these poor families across America and bringing them to the upper class? I looked into that, and true, there are stories of people from poor families coming to Harvard Law and getting a pathway to the upper class through Harvard Law, but 70% of students come from families making more than $95,000 a year and have more than $175,000 in wealth. If you have the median net worth of an American family, you're in the bottom quarter of Harvard Law School. If you have double the median net worth of the American family, you're in the bottom quarter of Harvard Law School. This is a school that, though honorably is taking some students from poor families and bringing them into the upper class, the American dream, most students here, the story is that they're coming from the upper class and they're laundering their privilege through Harvard Law School to feel like you deserve it at the end because you did all this hard work to go to Harvard Law School, but you're coming in upper class, you're leaving upper class. And then the worst excuse, 10th excuse, and this is my end. There's nothing we can do. That's always the final excuse. I just have to say to that, there's a lot we can do. You got to set a vision of where you want to go. You got to identify first steps. You got to make a commitment to it. You got to meet once a week, and then you got to push at it. And here's some things you can do. You can start changing the culture. You can start setting a goal of 51% public interest and measuring it. You can start promoting a culture of civic ambition. My dad went to a school where their mission statement was be afraid to die before you win a victory for humanity. And they talked about it every week at that school. What if we talked about our mission statement every week at our school? You can start spotlighting civic intelligence instead of the cult of narrow analytical intelligence. You can start asking admissions to value civic merit instead of just intellectual merit. You can change the career culture by pushing EIP back or getting rid of EIP. You can aspirationally fund OPIA. You can change the curriculum by drenching the 1L curriculum in time. Give it a past, talk about the history of the law. Give it a present, talk about the reality of the law. Give it a future, talk about creative alternatives for the law. And you can change the cost. You can lobby for civil legal aid, to fund civil legal aid like we have in England. You can start moving towards a residency program like we have in the health system. You can continue to support LIP and debt relief. So I think this is a crisis we have an ability to address. And so I'd like to end with this, which is just, I've made my argument, but now I just wanted to, why is this random guy just talking about this? Why does he care? And I'd like to tell you the 3 reasons I care. First is, I may be the last millennial in America who believes in institutions. People are losing faith in institutions, and we need an institutional revival. Change comes not through a mythical day when we all take to the streets or the election of the perfect candidate. It comes from thousands and thousands of institutional reforms. And Harvard Law is the institution in our care right now, and we should push it to be better. Second, I believe we should judge an institution according to the preferential option for the poor. We should judge it through the eyes of outsiders. America has a version of this, the democratic perspective, which insists that we are to see America through the eyes of ordinary citizens. It's Eugene Debs saying, when I would be ashamed to admit that I had risen from the ranks, when I rise, it will be with the ranks. It's Fannie Lou Hamer saying, nobody's free until everybody's free. It's Frederick Douglass saying, what to a slave is the 4th of July. What would happen if we saw Harvard Law School through the eyes of the average American? Does the refugee who needs help getting across the border care that we're very good at moving money across borders? Does the mother getting evicted from their house care that we created a bunch of Supreme Court clerks? Does the Midwestern governor who wants more young minds for a fledgling state agency care that our job placement in New York is second to none? Seen through the eyes of America, we risk irrelevance. Finally, I believe we should judge ourselves through the eyes of our descendants. When our grandkids read about the early 20th century, they'll learn that it was a time when a very small group of wealthy and powerful people controlled the fates of their fellow countrymen. The small group allowed a quarter of our children to live in poverty, a fifth of our neighbors to be persistently lonely. It's destabilized our climate. It's allowed white wealth to dwarf black wealth 12 to 1 50 years after the civil rights movement. It's thrown most people into deep disempowerment and precarity. And when our grandkids ask what we did, we want to tell them we advance the legal interests of the many rather than entrench the power of the few. When we come back to speak at our reunions in the class of the year 2069 or 2068 or 2070, 2071, we want to tell them with pride how Harvard Law organized itself to break open that cabal. I don't think we don't do this because of the money or the prestige. I think we don't do this because we're risk averse. But as Dorothy Day once said, the biggest mistake sometimes is to play things very safe in life and end up being a moral failure. We're scared of not keeping our options open. But to grow up is to commit to something, to forego options for the sake of a cause or a place or a community that you have fallen in love with. The future belongs to those ready to make a holy commitment. Some say the purpose of professional school should be to help us keep our options open, but I say it's the exact opposite. The purpose should be to help us to commit to something. To do so is scary, but we need not be afraid. It seems impossible, but remember that the bedrock principle of democracy is surprise. Democracy has been deepened when disempowered people who were told they have nothing to add, nothing to create, nothing to say, surprised everyone. And it's also been deepened when powerful people that were expected to cash their checks and toe the line surprised everyone too. No surprise, no life. Surprise, it's all possible. Let's get to work. And I'd like to bring on Ralph Nader, who will elaborate on this in a larger context.
Thank you very much, Martin. And there are two people here I really want to thank. Martin Drake, who's holding up with some help, the Harvard Law School Forum, and Kate Thorson, who's holding up with some help the Harvard Law Record. And that's where you are, excuse me, that's where you're exposed to the law writ large. That's where you're exposed to the great issues of justice and injustice and the role of the profession. That's where you're exposed to the issues that you don't really get focused on in your classes. Your classes are, with few notable exceptions here, trade school classes. They're not professional classes. They don't teach you what it means to be a lawyer in contrast to what it means to be an attorney. They show you how to be an attorney, how to attorn for clients zealously, but not the other role that you are required under our professional rules of ethics. You are obligated, and nobody's going to force you, to look out for the administration of justice. That's the bigger question that lawyers are supposed to address, and the occupational questions are as attorneys, right? Well, when I was at law school, we never discussed the difference between lawyers and attorneys, even though we had to be both under our code of ethics. We never discussed the difference between legal charity and lawful justice. We never discussed a lot of things. The curriculum was empirically starved. We never talked about trial cases. All the case books were on appellate cases. And in the contracts case book, I desperately searched on the second day of class for any cases on slavery. In the property case book, desperately searched any cases on slavery. They filled the courts, litigation over slaves. Property, slaves were property. They filled the courts with conflicts over contracts, different plantation owners fighting over slavery and contracts. Never was there such a case. You want to know why? Because West Publishing wanted to sell its case books in the South. Never discussed it. It was an unreal atmosphere. It was during the McCarthy period. Finally, a major dean stood up and challenged Joe McCarthy. It was Dean Erwin Griswold, the Harvard Law School. That was considered a very bold move at that time. But I started going to class. I couldn't believe what I was seeing. I entered Harvard Law School from Princeton. I had a cultivated sense of injustice because I read a lot of history, like Pete Davis does. Readers think, thinkers read. They don't just look at screens and engage in text messaging. And when you have a sense of injustice, you're able to understand the requirements for justice. If you don't have a sense of injustice deep within you and broadened out in context, you cannot have a sense of justice. What kind of injustice sense do you have beyond identity and justice? So I'm sitting in these courses, and I just shake my head with disbelief. First, they acculturated us with jokes. Like a professor once said, here at the Harvard Law School, we teach trust in the morning and antitrust in the afternoon. Ha, ha, ha. Another professor said, you know, at Harvard Law School, look how prophetic this is. We contract the law of torts, and we distort the law of contracts. And 60 years later, we've lost the freedom of contract. 99% of the contracts we sign are contracts of adhesion. And we're losing our right to a trial for a wrongful injury. The doors to the courtroom are closing. The number of jury trials is precipitously down from 30 years ago in both the federal and state courts. Who's complaining? In the contracts and torts, we were taught by brilliant professors. If you didn't believe it, you just had to ask them. They left out some important ingredients. We never had a minute of discussion of the underutilization of tort law. The fact that well over 90% of wrongfully injured people never see a lawyer, much less a plea, much less a trial. We were never taught about contracts of adhesion other than one class in the entire year. One class. Why? That's not where the jobs are. The jobs are representing corporations who write these contracts. Why would we want to challenge them? Why we would want to use words like contract peonage, contract servitude? Everybody in this room is a contract peon. You sign on the dotted line, you click on the dotted line, dare you to change an item, dare you to double the warranty. We had a course called Landlord-Tenant. We scarcely got to the tenant. Why? There are more tenants than landlords. Because that's not where the jobs are. That's where the money is. The money is representing landlords, not tenants. The obtuseness of the law students was staggering. In order to develop some level of equanimity, I offered my services to the Harvard Law Record. And I started writing articles. And I discovered that 11 states prohibited women from serving on juries. It's rather disturbing to me. And I wrote up the article, and there was total silence. This is when everybody got the record in print. Total silence from the students. Who cares? You had 15 females and 550 students. They were prohibited from even going to the Harvard Law School in 1950. Who cares? Professors would say to me, well, you know, a seat at the Harvard Law School is too valuable to have a woman who's just going to graduate, get married, and have babies. And the students didn't care. I wrote an article because I traveled through the Indian reservations in the prior summer, from Navajo to Crow, on American Indians. It was called American Indians, People Without a Future, 10,000 words, with pictures for the Harvard Law Record. Next day, total silence. Who cares? Except one student came up to me and said, what the hell are you wasting your time on this? You know how hard it is to get grades? I'm giving you a little bit of this because there's a lot of who cares now that you may not be aware of. Because Harvard Law School is the greatest brainwashing instrument in the history of American education. And it rewards you for being brainwashed. It rewards you very well for being brainwashed. You're overwhelmed with the way people refer to you and look at you and stand in awe at you when you leave the campus and they learn you're a Harvard Law student. Wow! A Harvard Law student. You must be smart. When I came back a few years after graduation into this room, the students were hanging from the rafters. Every seat was jammed. Probably the fire codes were violated because they were sitting in front of exits. Why? Because blacks were getting beaten up in the South, because women were starting to awake to their oppression, because the students didn't want to be drafted to go to Vietnam and kill Vietnamese, because they started looking at toxic pollution as a form of violence, however silent and cumulative it is. That's why they showed up. Part of it was they had skin in the game. And when they showed up, we didn't have pizza. When they showed up, it was in the evening. When they showed up, we could go to 11 o'clock and discuss things, not start watching some of you leave by 1 o'clock. Who cares about the class you're going to miss? Are you ever going to remember it? Are you ever going to hear someone like Martin and someone like Kate and someone like Pete to try to get you engaged? And forgive me if I'm talking to some of you who are already active and have some of the bruises and the field of the injustice in America. All institutions and all bureaucracies of a certain size, from government to corporate to union to universities, lie to themselves. They're called myths. That's how they exist. That's how they continue. That's how they dominate. That's how they control. What is the lie of the Harvard Law School? Other than the refusal to engage. Aha! You have the Socratic method. Isn't that wonderful, 1Ls? Have you realized by now that it's a game only one can play? You're supposed to question everything at the Harvard Law School, even the decisions of learned hand, except Harvard Law School, except corporate law firms, except a report by Pete Davis. Do you know how rare critiques of Harvard Law School are? There are about 3 of them in the last 40 years. But Dean Manning couldn't be disturbed in order to reply to the student body. He couldn't be disturbed in order to reply to about 8 or 9 distinguished alumni who asked him, when is he going to reply to this report? He finally replied, never mentioned the report, talked about pro bono and how they're relieving some of your debt burdens to their credit. But he didn't talk about the report. This is supposed to be an intellectual institution. It's not supposed to be an institution of silence when the students at the bottom are basically crying out, give us some freedom to practice for justice. Lift the yoke of the debts from us. Show us the way. Silence. What kind of elders do we have here? What kind of wisdom do we have here? When Dean Minow is photographed in the Harvard newsletter embracing at a function Lloyd Blankfein, the chairman of the board of a criminal enterprise known as Goldman Sachs. But she didn't have the time to come to the greatest gathering of civic leaders for justice in modern Harvard Law School history, right here in this courtroom 5 years ago. She didn't have time to come to other similar ventures, nor does John Manning. Why do you tolerate this? They're supposed to be your servants, not your masters. They're supposed to be your guiders. You tolerate it because you come here fact-deprived. You have no idea of the insinuation of power in our society, in the world, other than a few have the power and they decide for the many. But what really gets you activated is how this power is deployed and how raw power triumphs again and again every day over the rule of law, of how the myths that the president is not above the law, the Congress is not above the law, no one is above the law, is a monstrous lie. The President of the United States is completely above the law in foreign and military policy and exercises it every day in ongoing criminal wars of aggression. I suggested about a year and a half ago that your curriculum be split in two. Those of you who want to engage in a normal practice of law, commercial law, property law, securities law, tax law, fine. You have the courses. Those of you who want to practice in the law as a myth, in integrated and established and institutionalized lawlessness, which is the norm, not the exception, for the privileges of the rich and powerful, you have your own curriculum. And then you feed out into those careers. You don't just dress up your vitae and go into Cahill Gordon or Cravath Swain or Covington and Burling. If you don't have that kind of frame of reference, you can't take your own sense of moral sensibilities and develop them into application for this professional education that you're reputed to be undergoing. Has it ever occurred to you to explore the size of Harvard Law School's endowment? Does anybody know what the endowment is? Huh? 37 million? Billion. No, we're talking Harvard Law School. You know what the endowment Harvard Law School is? Well, 10 years ago I was told it was bigger than all the endowments of all the other law schools in America. It's well over $1 billion. Why isn't that reducing tuition? Why isn't that starting public interest law firms all over the country? So instead of telling you, go and do well, my children, look at the motto of Harvard Law School. Quote, this is their motto for decades: to educate leaders who contribute to the advancement of justice and the well-being of society, end quote. With a few exceptions, that's a mockery of those words. The architects of the deployment of raw economic, political, and social power over the rule of law come from Harvard Law School, Yale Law School, Columbia Law School. They're the architects, informally, on their retainers with giant corporations, and on the courts, on the bench. Look at the Supreme Court. 5 members of the Supreme Court's mission is to mature and install the corporate state. Let's not kid ourselves. They're ideologically driven. You saw it in the Brett Kavanaugh hearings. You saw it in the opposition here. Now, let's just look at a few patterns of lawlessness. And by the way, this pile over here is 3 articles that were in the Harvard Law Record that I wrote, and so you can get them on the website, and they're reprinted there. I must tell you, I would rather not have you have to read my articles. I'd rather have you read other alumni articles, but they just don't seem to be around. How many of you heard of the Appleseed Foundation? All right. One time we met at a reunion, the class of '58, 60th reunion, this weekend, here. And we said, a half a dozen of us in Washington said, what are we doing at these reunions? I mean, who wants to compare cases and victories? We're beyond that. Let's start a foundation that starts public interest centers all over the country engaging in systemic justice, not legal charity. And for heaven's sake, we actually did it. And we got to 12 or 15 people. They're not big centers, Texas, Illinois, little one in Massachusetts, South Carolina. but they exist. Imagine if every law school class did that, 30 years out, at all the law schools in our country, 205 of them. We would allow the law to be used by millions of people for once. Well, do you know that when we started the Appleseed Foundation, and some of the classmates of mine were big givers to Harvard Law School, we got a cold reception from Dean Clark? Instead of saying, wow, you're trying to provide opportunities for our students, we tell them, you know, be idealistic and advance justice, but there are no jobs out there. We got a cold shoulder. They didn't even want to give us the meetings of the Harvard Law School Association chapters that were coming up around the country, or have a role at the reunions, until we said, cut it out. Imagine that. Let's take 4 patterns of lawlessness. I have to say quickly. 1 is the government. Where's the sense of urgency, I ask you, at Harvard Law School? You know what's going on in foreign and military policy. You've read about Eisenhower's warning about the military-industrial complex. He wanted to say the military-industrial congressional complex. Okay? This may shock you, but it shouldn't. We have now, this is how far it's happened, and the architects are lawyers. We have now secret wars, secret prisons, secret legal opinions, secret evidence, secret budget appropriations, or no appropriations. Black budgets are called. And redacted judicial opinions. Can you imagine? You open up now appellate decisions, and they are redacted here and there. We have a president, no matter who he is in the past, who is the prosecutor, judge, jury, executioner, and cover-upper. Immune from congressional accountability under congressional constitutional authority and duty, like the Declaration of War authority. Does that bother anybody? The people that should bother the most are the people that are supposed to have the most articulated and cultivated sense of illegality and injustice. Hardly a ripple at 205 law schools. Watch out for the ethnic and sexist slur, however. Watch out for the racial verbal slur. You're in trouble in 205 law schools. But empire, the murder and omnicidal attacks on Iraq, the support or the brutalization of Palestinians, the blowing apart of Afghanistan, Hillary's war in Libya, which has spilled over into 6 African countries, the activation of much greater militant opposition to us coming to this country, wait and see. We've had a long holiday from the U.S. empire being retaliated against other than 9/11. Any sense of urgency? Any breaking of daily routines? Let's try another one. Mass commercial crimes. Those of you who are going to go work for large corporate law firms will be turned into criminals within 6 months. Does that surprise you? Do you know what I'm talking about? Padded billing. Show me a corporate law firm that doesn't pad its bills, and I will show you a visiting Martian. And they teach you early. Some of them are really egregious. They'll tell a young associate, okay, you had a nice summer internship, gave you free tickets to the ball games, $10 desserts. Now you got to get down to work. And you better give us 2,500 hours of billable services. In fact, there have been law firms demanding 3,000 hours. You cannot give a law firm 2,500 hours, or many would argue even 2,000 hours as a young associate without engaging in crooked billing practices. Not to mention what the senior partner will do for you as you carry the briefcase into the rare courtroom, and what that partner will bill for your services of learning on the job. Not far from here is a man called Malcolm Sparrow. He teaches at the Kennedy School. He's an applied mathematician. He's the authority for the following assertion. As a minimum, 10% of all healthcare expenditures are defrauded. That's $350 billion with a B dollars this year. Not small change. He says it's the smallest estimate he could come up with. It's probably much more. Not more than $7 billion is recovered by Medicare and others. Let's think of that. $350 billion is half of the defense budget, bloated as it is. $350 billion would cover all the Americans who are not covered by health insurance. Any activity? The law schools? Do you invite him over to speak? He's never been invited. Who are the architects of this kind of fraud? Who are the insinuators of immunity, impunity, legal wars of attrition? Should there be prosecutions? Who are the ones who go up to Capitol Hill and restrict corporate crime enforcement budgets? The corporate attorneys. Those who belong to what the press unconsciously calls prestigious corporate law firms. Prestigious. Let's take another one. How many people were killed in 9/11? About 3,100. It was a slaughter. Johns Hopkins School of Medicine. The latest report, there have been prior reports, Harvard School of Public Health, etc. 2 years ago, estimated, this was their rock bottom, that in hospitals alone, 5,000 people die every week in this country. Every week from preventable problems. Doesn't count clinics, Medicaid mills, or doctor offices. 5,000 a week. You ever hear it talked about in election campaigns, including progressive Democrats? Do you know how many next of kin find a lawyer? 1% maybe. Most of them don't even know they were malpracticed because the records aren't kept in that manner. Hospital-induced infections, incompetence, negligence, 5,000 a week. These are real people. They're not statistics. Who weeps over them? Who investigates for them? Who teaches about them in Torts 1 or Tort Seminar 2? And that's the rock bottom estimate. You go into the clinics and the doctor's offices, you're up to $400,000 a year. Some of them are outright criminal greed. A lot of them are criminal negligence. A lot of them are just errors. But that's what insurance is for. Even if they're innocent errors, they're supposed to be a remedy. They're supposed to be insured. If you can't internalize those externalities, how are you going to deter? How are you going to disclose to the public to demand regulation of the hospitals and more disclosure? What do you learn in law schools? In tort law and contract law. There are many other patterns of lawlessness. They are a challenge to the intellect. When I was at law school, the word justice was considered soft. Imagine that. This was before the Chicago School of Economics turned the word justice into a non-word. It's all marginal utility. It's all, quote, consumer welfare, quote, grotesque as they turned that phrase into. How many of you know Judge Posner, the Circuit Court? Brilliant, Harvard 62, Harvard Law School. Writes a book on the side every year. This is an eyewitness account. He taught at University of Chicago Law School. Walks in, says, greetings, everybody's awed. Turns around, writes on the blackboard the word justice. Turns around, faces the students, says, see that word? Yes, Judge. That's the last time I want to hear it in my course. You know what's happened since? He quit the bench in order to devote the rest of his life to expand legal aid for criminally accused indigenous people. You see how long a brilliant jurist takes to see the light? To his credit. At least he did it a year and a half ago. Read about it in the New York Times. This is why you have to worry about people calling you smart and bright and brilliant. That's the way to put you in a soporific state of mind. So, in case you think that this is a delivery from an off-the-scale legal advocate, I want to tell you what some old corporate lawyers once said. Henry Stimson. How many of you have heard of Henry Stimson? Okay. In the 1920s, he was the biggest corporate lawyer. Everyone looked up to him. He also served for 6 presidents. Here's what he wrote about the passionate necessity of the American lawyer to be a defender of the laws and the Constitution. Quote, I felt that if the time should ever come when this tradition faded out and the members of the bar had become merely the servants of business, the future of our liberties would be gloomy indeed, end quote. That time has already come. Thanks to the ingenious advocacy of corporate attorneys, I wrote in 1996, in conjunction with the stiffening matrix of corporate power, there is an accelerating imbalance between individuals and corporations, both within and outside formal legal frameworks. The growing double standard between the procedural and substantive rights and powers of artificial persons, i.e. corporations, and real persons is one of the most momentous and disturbing handiworks in the history of American law and its brilliant counselors. You're going to go into that tradition. Who do you think defended and helped cover up the destruction of the tobacco industry? Year after year, 400,000 deaths a year this year, tobacco-related diseases. We're finally waking up to it in the last 20 years, thanks to a handful of people. It was corporate lawyers. You know how clever they were? When the anti-tobacco movement got underway, we wanted to get into the laboratory tests of the tobacco companies in order to prove that they were lying about the effects of tobacco smoking and health. And you know what the corporate lawyers figured out? How clever. They delayed for years. They put her under lawyer-client privilege. The people who represented Lockheed Martin and Boeing and Raytheon to rip off the taxpayer in bloated military contracts, decade after decade. Finding ways to cover up failed weapon systems requiring more billions of dollars, like the F-35. They were corporate lawyers, your predecessors. You go into these corporate law firms, you follow orders, or you're done. They may give you a criminal case against a impecunious accused, so you can dress up your fig leaf, call it pro bono, but you show that you've got a conscience when you go to work. You show that you're a primary human being as a lawyer that has to overcome your secondary human being as an attorney in instances of gross lack of ethics or illegality. You're done. You're put on the Standard & Poor and rating bond retainers, and you show they're faking, which led to the collapse in 2008 of Wall Street, 8 million jobs lost, trillions of dollars wasted, pensions, mutual funds. You challenge that, you're done. You do the architecture for the cover-up, you get promoted. You get a bonus. You want to represent Monsanto, that's strategically planning our genetic inheritance, flora, fauna, and human genes, you'll get promoted. If you raise serious ethical questions raised by the Council of Responsible Genetics, set up here by Harvard and MIT scientists years ago, you're done. Is that the kind of life you want to lead? Do you want to look back on your 15 or 17,000 fast days of legal practice? It goes like this. Do you want to look back at that and say, I missed the justice bandwagon? I was the architect for the raw power corruption of the law. I twisted the law to exempt my client from a criminal penalty, lobbying Congress for willful and knowing violation of automobile safety standards or pesticide standards. What do you want to look back on? Fortunately, most of you here don't need to hear my words because you're here. You showed up. Half of democracy showing up for town meetings, rallies, marches, courtrooms, legislative councils, city councils. It's the empty seats that are not getting the message. But fortunately, this whole hour or so is being recorded by video and will be on the Harvard Law School website and probably in the Harvard Law Record website. Now I can see the time is ending, but let me tell you what wonderful retainers you're going to have in the next 10 years if you go to Wall Street. If you see this article in the New York Times called Prepping for the Next Crisis, what was the next crisis? The collapse of Wall Street. And do you know who wrote this article? Do you think this article was written by a leading Marxist scholar? This article was written by people who are saying the Republican Congress is weakening federal law to head off another massive bailout, massive recession, massive destruction of trillions of dollars of wealth. You know who these authors are? Ben Bernanke, former chairman of the Federal Reserve. Henry Paulson, former chairman of Goldman Sachs, Secretary Treasury later. And Timothy Geithner, Secretary Treasury coming from Wall Street context. Is that all that business you're going to have? You're not going to know what to do with all those bankruptcies, all those bash pension funds, all those litigations. Isn't that wonderful? when you get into your car and you communicate from Greenwich or Darien into the pits and come back? What are you going to do when your 13-year-old says, "What'd you do today, Mommy, Daddy?" What are you going to tell them? It all comes down to conversation, reading, and thinking, doesn't it? If you're too wedded to that cell phone, which if Marx was here today would say, not religion is the opiate of the people, that was his phrase, he would say the cell phone is the opiate of the people. The more you get together, person to person, the more you read and the more you think, the more you converse, the more you'll realize that it almost never takes more than 1% of the people in this country representing deep-seated perceived injustice and majority opinion to turn the country around, no matter how powerful corporations are, no matter how embedded they are in our government, no matter how indentured Congress is, the people can prevail. They start with "we the people" in the Constitution, as you know. The Constitution never mentions the word corporation or company, never mentions the word political parties. How in the world did we ever end up being dominated by both? The corporation does not start "we the Congress," does not start "we the corporation." We already have the sovereign power. We don't have to seize it. The greatest wealth in this country is not owned by the wealthy. It's owned by the people. It's called the commons. Never taught at Harvard Law School. Civil rights, there wasn't a course when I was there. Consumer rights, never a course. Women's rights, no seminar. Environmental, no seminar. That's called preparing law students for the next 50 years? You see the myopia? You see the arrogance? So we already have the sovereignty. We own the public lands, 1/3 of America, not to mention offshore. We own trillions of dollars of pension funds that own a lot of New York Stock Exchange companies. We own trillions of dollars of government research and development that built Silicon Valley, built the pharmaceutical industry, the aerospace industry, the containerization industry, the biotech industry. They didn't build it. The basic research came from the taxpayers, and they took credit for it. All the internet, commons. But because of corporate lawyers, they've split ownership from control. So we own all these assets, but we have ceded temporary control to the corporations, the timber companies, the oil and gas companies, the broadcast companies. That gets into our brain, so our expectations are down. We feel powerless. Oh me, oh my, you can't do anything. It's drilled into us from the first grade on. Just get in line. Shut up and buy. Learn how to believe, not think. Learn how to obey, not dissent. Elementary school, high school. You start with the sovereign power. You start with the power of the commons. You start taking back ownership, wedding it with control. Why are we giving away our hard rock minerals? Did you know that? We're the only country in the world that says to any foreign or domestic corporation, come onto the federal lands, bring your geologists. If you find gold, silver, molybdenum, lead, you can get it for $5 an acre. Can you believe that? Barrick Gold in Canada discovered $9 billion worth of gold in Nevada on our lands. That's our gold. They got it for $25,000. You see what happens when you split ownership from control? Is that anything that law schools are worried about? Do you see small talk among the students about these issues we're discussing today? What is the small talk between classes? Ask yourself. I must say, in the 60s and 70s, small talk was big talk more than it is today among students. All right, so we have the sovereignty, we have the resources, we can have our own TV and radio stations. It's our property, we're the landlords. The radio and TV stations are the tenants. Thanks to Congress and the FCC, they pay us no rent. Isn't that wonderful? 24 hours a day, they decide who says what and who doesn't. Why do we take that? Because we grow up corporate. We grow up understanding that that's the way it is. We don't grow up civic to understand that that's the way it doesn't have to be. It doesn't have to be. And the first responders with that attitude, if you will forgive my professional narcissism, is our legal profession. It's the only profession that can synergize the knowledge of all other professions and reshape power to obey just laws and to liberate the creative energies of the citizenry for their own private institutions and self-reliance at the local level. And instead of exporting weapons of mass destruction, exporting fast food that is devastating the health of people in Brazil and Nigeria, New York Times articles recently, expanding childhood obesity with our fast food, junk food and drink, instead of exporting oligarchy, exporting tax evasion techniques. Why don't we export the best in us? Because we don't have a functioning democracy worthy of the name. The reason why people like democracy, it brings out the best in people. Dictatorship brings out the worst in the few to oppress the many. I wrote something in 1996. It's in the library. Got a great library. It quotes Brandeis talking about, we hear much of the corporate lawyer, far too little of the people's lawyer. But then I decided to write a paragraph for the law students. And Pete went over a little bit, but it's worth repeating, because you're going to be asked to do this. In 1970, the law students sent a questionnaire to all corporate law firms coming to Harvard Law School for recruitment, and they demanded to know, what's the pro bono range? To what extent can you turn down a client, like if you didn't want to work on the tobacco account? And you know what? Every corporate law firm answered that questionnaire. See the difference? The law students of those days, and I don't want to overgeneralize, they had a higher estimate of their own significance than the law school students today. If you don't have high expectations of yourself, you're not going to demand more of our system of law and the widespread, broader utilization of it to curb, shape, destroy raw power. Here's the section. Quote, I'm quoting myself here. Attorney excesses on the behalf of clients thrive when there is an imbalance of advocacy and power on one side of the case or negotiation. That's the theme of Pete's report. And here are the examples. Put yourself in the position of a young attorney here. The coal company attorneys who created the notorious broad-form deeds by which they obtained from the impoverished and desperate Appalachian and rural people in West Virginia, Kentucky, for 50 cents an acre, 50 cents an acre in the 1930s. The right to all coal, oil, gas, minerals, and metals the right to divert and pollute water, and immunity from all liability. How would you like to have drafted that broad form deed? How would you face your children with that? How could you face your people of faith with that? But they did. They drove those poor people into the ground, semi-starved in ill health, crumbling schools. Nor did attorneys for banks, hospital chains, and employers behave as lawyers. They developed the compulsory arbitration clauses in the fine print of bank signature cards, insurance policies, hospital consent agreements, and employment contracts that took away the legal remedies of unsuspecting people. They took away the right to go to court and have trial by jury. No government can do that. But fine print contract attorneys can. Do you know who the leading architect in a corporate law firm is? Who brags about it? He is the leading architect of corporate peonage and servitude. He's in Philadelphia. We want to make him a famous person. We want to nominate him as the leading contract slaver in the United States. He's proud of it. He goes to meetings with consumer advocates and brags about it. That's because we're not doing our job in stigmatizing these lawyers or taking them up before the Board of Ethics. Nor did the attorney lobbyists who damaged the equity of the tax laws for a quick retainer, knowing that the harm extended well beyond anything required to meet their clients' interests. Nor did the attorneys for the banks and other financial firms who aided, abetted, or condoned the looting of savers and investors by management. Nor did the attorneys who, with investment bankers, pushed for huge fee-generating leverage buyouts loaded with debt, knowing that the top executives would reap the largest riches, while workers, communities, and shareholders would be made to suffer, and suffer for a long time. Nor the attorney union busters, whose crude and cruel tactics destroyed not just the prospects of decent livelihoods for working families, but also the workers' belief that the law could work for, not against them. Sometimes it takes a lot of examples to drive the point home when you talk to your friends and your fellow students, and you get them to realize that we desperately need them. We desperately need you. We're not flattering you. We're not toasting you. We desperately need you. For without the law, what is there? Without the law, there's no justice. Without justice, there's no liberty. There's no freedom. There's no suppression of violence, which is everywhere, domestically, locally, nationally, internationally. Harvard Law School has led in suppressing the styles of violence that come from the rich and powerful, and making you think that most of it comes from street crime and domestic crime. It isn't even close. Millions of people are dying every year and getting seriously injured because of corporate crime, fraud, and abuse, with impunity and immunity. And that reprint has got some of the statistics, and I mentioned some of them. So just let me anticipate one response, because among you are the future John Boltons and Michael Pompeos. Pompeo graduated from Harvard Law School, and he proceeded to be a lawless individual. He's an Islamophobe. He's an anti-Semite against the people in the Arab countries and Palestinians. He has supported, when he was a member of Congress, totally criminal wars of aggression and urged more of them and he's a graduate of the Harvard Law School. He's now Secretary of State. John Bolton graduated from Yale Law School. A few months ago, before he's appointed National Security Advisor without confirmation, that's unconstitutional, but that's another subject. He wrote an article for the Wall Street Journal urging the bombing of North Korea. Hey, any legal authority for that, John? The overthrow of the regime in Iran. Hey, you mean without declaration of war by Congress, John? What kind of beasts of prey are graduating from these leading law schools? What kind of education did they avoid absorbing? We're not talking shades of gray. We're not talking reasonable people can disagree. We're talking outright war criminals. Textbook war criminals. Undeclared wars. Unappropriated wars. Unauthorized wars in Congress. Wars by executive order. Wars by presidential diktat. Wars by presidential outlawry. We couldn't even get the Harvard Law Review interested in the subject. The Harvard Law Review? How far is it from Austin, the courtroom here? Hello there. You think any one of them would come here and sit? They're too busy becoming future well-lubricated spokes of the giant corporate machine. Anybody here from Harvard Law Review that I can express my apologies? Oh, there, hey! Give that person a hand. Any law professor here? Hey! Any clinical leader, whatever you call them, the lawyers who run your wonderful 30 clinics? Anybody here? Huh? Now, I may be accused here of excessive self-importance. Believe me, I have the most modest ego. If you look at all my writings, I have the smallest number of eyes of anybody in literary history. But I have to make my point, don't I? Because I only have about an hour. Although I'd love to spend 10 hours with you. I have to make my point. I have to try to make it with one imprint or another, because it's not just what you say, is it? It's what they hear. It's what they hear. And we're heading into an election contest where it may happen all over again. The Democrats may blow it. The polls are tightening. They're not making issues at FDR and Truman and LBJ like front burner living wage. 30 million workers making less today, inflation adjusted, than workers in 1968. That's a lot of voters who aren't voting because they don't see why they should vote. Go vote for a long overdue raise. You're lucky, they're lucky you don't demand back pay. So let's not underestimate our profession any longer. Let's hold it up to very high standards, all 1.3 million of us. When Mueller throws the gauntlet down to Trump, and Trump decides to go further rogue, throw the law to the winds, flaunt his pardoning power, go to rallies all over the country, fire the people in the Justice Department, put someone like Giuliani in, and then tell the country, sue me. Dare you to sue me. Got Republican cover in the Congress from impeachment. What are the students and faculty at Harvard Law School going to do when this constitutional crisis hits the road in a few weeks, perhaps? Are you ready? Can you break your routine? Can you cut your classes? Can you be given permission to not go to the classes? I must say, Pete has a lot of good recommendations, but one of them I don't think is in the book. This is it, our bicentennial crisis. There isn't a law student in 100 years who's written something like this. Just mere respect would make every law student read this book. It's about their future. But then we put together this called What Every Harvard Law Student Should Know, that they don't get exposed to in law school. It's written by different authors. We passed it out free when Pete was 1L. People picked it up. No response from the professoriate. Do you know what the concordat is between Harvard law professors and the dean administration? Don't you know what the deal is? There are very few exceptions to this characterization. Here's the deal. You have on the faculty a lot of smart people who are socially conscious. You have some who are very smart who are technicians. That is, they can't tell you anything about the future because you can't footnote it. That's what the Harvard Law Review is about. Here's the deal. This is from a distance. I'd like to be proved wrong. The deanship and the administration says, we'll let you professors pursue your topics, write your law review articles, testify, moonlight. Don't mess with the central purpose of this law school, which is to provide very well-paying jobs in the institutions of power that run this country and a lot of the world. Just don't mess with it. We'll give you a certain amount of autonomy. Don't challenge us. If we only knew what was in the minds of these professors, and if they only spoke publicly, and not just Professor Unger or Professor Hansen or Bebchuk, others, we'd be able to turn this law school around faster once that veil of self-censorship was lifted. Let me just end on this. For those who are going to come out of here, corporatists or conservatives, I've never met a conservative who calls herself corporatist. But I've met a lot of corporatists who call themselves conservatives. Conservatives do not like empire. They do not like the Patriot Act. They do not like fine print contracts. They are civil libertarians. Conservatives do not like corporate welfare. They do not like crony capitalism. That's why corporatists like to say they're conservatives. But let's not quibble. Let's say there are going to be a few of you that are going to be hardcore establishment. And you say, oh, look at Nader. He thinks there's a corporate criminal in back of every lamppost. He's exaggerating. Believe me, this is an understatement. This is an understatement. And what you heard today was an understatement. Just look what's happening around the world. Over 100 countries were entered by special forces. We have bases in 130 countries. We now have a president who can say, we're getting out of a treaty without calling on the Senate to withdraw the intermediate nuclear. We're starting a massive arms race. You know what that means for public budgets, for every schoolhouse, for every drinking water system, for every public transit? Do you know what it means for the future of our country when we get into an arms race with China and Russia, provoked by the United States and the military-industrial complex? Is this how you want to spend your next 15, 20,000 days? All right, so they go out there and they say Nader's exaggerating. So let's put it in polite language. Big corporations are all about strategic planning. They don't like unpredictability. They like certainty. That's one reason they merge and acquire other competitors. They don't like the uncertainty of competitive markets that can dislodge them. So they're all about strategic planning. And years ago, there were certain boundaries to the commercial zone in our culture. And they didn't strategically plan what they now are planning with no boundaries. They are strategically planning our elections. They are strategically planning our government, our policies, our public budget allocations, our military contracts. They are strategically planning a lot of our foreign policy. They are strategically planning the nature of our food, fast food, junk food. They are strategically planning bypassing parental authority and exploiting children, which was a taboo when I was growing up. You never marketed directly to kids for their diet, for their drinks, for their violent programming so intimately. They are strategically planning our permissibility of pollution. They are strategically planning our law of contracts, as we know. They're strategically planning our access to justice and the law of torts. They're strategically planning the utilization of the public lands, aren't they? Minerals, oil, gas, timber, grazing. They're strategically planned our tax system, haven't they? And you know what else they're strategically planning? Our genetic inheritance. They're already strategically planning the nanotech industry, the biotech industry, and the artificial intelligence industry, making sure they do not grow within definable legal and ethical boundaries. The Wild West. And when you add it all up, they are a clear and imminent danger to the world, to the country, and to the communities in our country. They may have people who teach Sunday school, who get embraced by Harvard Law School deans, who provide great charities to the Metropolitan Opera and to children's poverty groups. But you know what that's all about. That's cover. That's guilt conscience in a very limited fashion. I ask you to liberate your minds and your imagination, to have a high expectation of yourself, to be able to persuade others who may need your counsel here at the law school and among your future clients. And if we don't redistribute the deployment of lawyers in this country from favoring the few to control the many, our profession deserves its ranking in the polls year after year, which is below used cars dealers. Instead of being seen as the tribunes of justice, the fearless first responders against injustice, which Daniel Webster once defined justice as the great work of human beings on earth. Freedom was defined by Marcus Cicero as participation in power. Has anybody done a better definition of freedom? And then there was the 14th century Ming Dynasty philosopher who gave us this pearl: to know and not to do is not to know. Harvard Law School is full of to know. It has some to do, but the penumbra that is labeled not to do is much, much larger. Save this institution from its own pretensions. It never takes more than 1% of any constituency, including the law school, to change this institution. All these changes that have come here, opening it up to women, to minorities, having clinics that deal with real people's lives, opening up to seminars and courses about real travails of people, came overwhelmingly from your predecessor students. How many? 10, 5, 15, never more than 1%. But they represented the growing public opinion of more passive students in their class. There are always some professors who were involved as well. And from that history, you can take your energy and your foresight. And we'd like you, we're serious after this is over, to come up here. Those of you who want to work on the Harvard Law Record, Kate's here, want to work on the Harvard Law Forum, where you meet wonderful people who have changed things and done things. One of them coming up who exposes corporate personhood is coming up, I think, in a few days at the Harvard Law Forum. They really need your help. And those of you who really want to change the law school, they really need your help. How many? 15 of you. 15 of you in each class can change this law school, especially when you stand on the shoulders of Pete and others who've gone before you. And I'm sure Pete will come regularly here if you want him to be part of this effort. Now, it's usually the tendency of orators to wind up with some stirring phrase. I'm not going to do that. I just want to wind up with you showing up here after we convene. Thank you very much. By the way, I got into auto safety because I wrote a third-year paper on unsafe automobiles. I actually got a top grade. The professor didn't know what I was talking about. There's too much engineering stuff. But use your third-year paper to break open what you want to do in your professional life.
We have time for a couple questions, if anyone has any. Yeah, I can bring you them.
Ralph, what do you think of the trial that's underway now in Boston over the Harvard's admissions policies? If you've followed that at all, and what you think of it, and is there any part of it that's relevant to the law school?
Yeah, I haven't been following it much, but it's unloading a lot of important information, I think, as lawsuits do. But I think it's a point Pete made in his book. One of the points is, watch out when you have diversity, but diversity that comes from upper income people. So diversity often is associated with diversity in class as well as ethnicity, race, and gender. And that's not necessarily the case with Harvard in terms of its admission policies. And there's plenty other to discuss, obviously, those of you who are following the trial.
I have a question on antitrust and
yes, sir.
its importance in public service.
Can you speak louder, please?
Yeah, I have a question on antitrust.
Yes.
And its importance in public service. Could you tell us more about it?
Yes, well, he's leading an effort, he came up earlier, to deal with antitrust from the standpoint of consumer income. And now there's a recent law school graduate from Yale who's challenged Amazon, Lena Khan, who's challenging it on the original inspiration of antitrust, which was inequality of power, leading to competitive disadvantage. And believe me, Amazon is very afraid of this young woman. I know that from inside sources, the power of the idea. Yale Law Journal published. Yeah, antitrust has to be revived. It reached its lowest ebb about 25 years ago. I helped organize with a former FTC attorney, the American Institute of Antitrust, which mobilized people who believe in competitive economies and economic democracy. So I'm very happy to hear that you're doing this. Anybody who's interested in this, just raise your hand. I'm sure he'd be very happy to talk about what he's doing, and he gave me his very cleverly artistically depicted website.
I'll add that in the book we have a section on antitrust about inequalities of power. That $18 million that I referenced from the Olin Foundation, a lot of that was to have law professors come in and start changing the definition of antitrust from about inequalities of power to about, the numbers of, consumer prices, which would drastically limit it. And I have a section in there on the revolving door between antitrust oversight and antitrust corporate law firms. The vast majority of assistant attorney generals for antitrust under Obama are now working for corporate law firms helping gut antitrust.
And there are a few copies of this for those of you who really want to read and use it. I guess it's, where is it? Yeah, they're over there. Another question?
I think we'll cut
Is
it off
there-
there.
There is, was there any hand up? No? There's just one other thing I'd like to say, and that is the moonlighting of faculty here, if they volunteer, is on a website. Some of the faculty think that it was a laceration of their right of free association. They don't put what companies they moonlight, but others do put what companies they moonlight. I think as students you're entitled to know that. So anybody know what it's on a website. The law school sponsored this.
Yeah, this is a reference to professors here that work for corporate clients
Yes.
outside of their work here, and they don't mention it to their students. Some of them voluntarily have filled out the disclosure forms, and it's on the faculty website
Yeah.
at HLS. Yeah,
I mean, you're entitled to know if you got an antitrust teacher who's moonlighting for General Dynamics or whatever. So you should look into that. It's as close as your computer to find it out. And then the other thing is curriculum. Pete mentioned the Olin Foundation. Imagine $18 million to teach conservative constitutional law. Well, Bruce Fine, who graduated here in 1972, he worked in the Republican Justice Department under Reagan. And Lewis Fisher, who's a legendary constitutional law scholar at the Library of Congress for decades, kept writing the dean 2-3 years ago that they would come up and teach a course on constitutional law that is full of reality of how much of constitutional law is a dead letter and usurped by the presidential office. And the dean, Minow, at the time, referred it to some committee, and it never emerged. So you see, the Olin money, $18 million, they get action. And Lewis Fisher and Bruce Fine are still willing to come up and give that seminar at the law school. So take an interest in the curriculum. If it's too much a reflection of raw power out there, too much a reflection on the most lucrative job opportunities out there, you're getting shortchanged badly. This is full recognition of your 30 clinics and all that. But it's the first year curriculum that's so important in orienting you for the second and third year. I guess we're good. Many thanks for staying here and making us look like a big act. Thanks a lot.